Hey, welcome everybody to Spin Legal on Wednesday, June the 19th, 2024. Today, Angela and I are going to be talking about the topic of the respective duties of the client and the legal representative. How does the client and the legal representative work together to achieve the results that they need? Okay, so that's an interesting topic. Hey,
Yeah,
good evening, Angela. How are
yeah,
you?
good evening, Peter. Things are great. We had lots of
Good.
busy clients today.
Sorry?
We had 8 people in the door today.
8 people in the door today. Let's make sure we've got 8 people giving us money.
Yeah, I'd like to go after them. Is Rocco around? Hate to do election work.
Yeah. Okay. Well, so let's start in that direction. The respective duties of the client and the legal representative. Once a client has retained their legal representative, there are distinct duties for each party, and that's what we're seeking to understand or have everybody understand in tonight's session of Spin Legal.
Yep. See, when you retain a client, there is a very specific relationship. Oh, Dwight joined the YouTube.
Yeah, Dwight Lamont says hi there. So there we
Hello,
go. Thank you.
Dwight. Yep. Yep. And this is one of the things that once a client has retained a legal representative, there are distinct duties for each side. This is a contract. When you come into and seek legal services with any firm, not just Invictus, but any paralegal or legal firm, you are formulating a contract with your legal services provider. Yeah, the legal services provider is, they're not your employee. You have to understand they're not your employee. They don't do girl and boy Friday chores for you, but they're there to help you. They are there as a consultant. They have an area of expertise that you need. Okay? You need to know what your rights are in specific situations. We also know how to enforce your rights in these specific situations. So when you come together with us and then you retain us to help you, we look through your case, we look through your evidence, we look through all the stuff that we need to look at to determine what the best legal strategy would be to help you achieve what you want to achieve. We can't provide you any guarantees. None of us can provide any guarantees. In fact, it's against our professional ethics to say you win or it's free.
Oh,
We
it's a
can't.
slam dunk. It's a slam dunk case. No, there's
Oh
no such
yes,
thing as a
I've heard that
slam
from
dunk.
clients sometimes coming in saying it's a slam dunk case, and I ask them. I said, "Well, if it's so slam dunk, why aren't you doing it yourself?"
Yeah. And
But
actually, sometimes when I've had clients come in and say, "Hey, I've got a slam dunk case for you," my gut feel is to say, "There it is. The door's over there."
but basically, you've come to us because you have questions, you have issues, or maybe something happened that's causing you a lot of distress. You lost a job, you're
Yeah.
being kicked out of your apartment, your landlord's giving you a hard time, somebody owes you money, and they said, "See you later," and they just disappear off the face of the earth. Or somebody died, and your brother or sister who's a trustee of the will, and you've been awarded, say, 35,000 in the will, and they don't want to give it to you because they claim that you owe them money. So there's different things that could be done. Small claims. Somebody comes in, cleans your kitchen, fixes your kitchen, and they didn't fix your kitchen. They've actually made it worse. So there's different things that you want us to help you with. And yes, we could help you. Okay, so you need to come in, we formulate that contract. It's
Actually,
called a retainer.
before we go too much further in this, let's point out that there are some times when, and we've had a couple of cases in the last couple of weeks where people have come in and we've talked it through and we've discussed what their particular case is, and we've said, I'm sorry. There was one instance where the lady's claiming like $1,500. I said, I think you've got a good case, you know, but unfortunately, it's going to cost you more than $1,500 to fight it for you, for us
Yeah,
to fight it for you, right?
exactly.
You know, essentially, those sort of people, they can claim through the small claims court and probably get the victory they need, and settle it most likely in a settlement conference. The other question might well be something where somebody comes in with a case, and there's a lot of complexities to it, but you find out that there's certain things about it that you just kind of go, well, this isn't the type of thing that we deal with. People, you know, we don't deal with this type of thing. So
Mm,
you might be able to say, hey, there's this lawyers or that paralegal that deal with this particular type of case, and you know, an honest representative is going to at times say, no, sorry,
mm.
this case, we can't help you on this particular case.
Yeah, there was somebody called me up, and it was a very sad, sad story. He called me up, and we talked about it last week with this gentleman, and we talked about it for a little while, and it involved a will, and it involved a family conflict involving the will.
Yeah.
And this was something, and there's some math factors in there. We don't work with that type of thing. So I gave the case and told them to go to this particular lawyer who handles that type of stuff regularly. Hey, so we try to help people when we can or give referrals, hey, where possible. Hey, but there are most people, more and more people in our community are starting to figure out. It says, okay, paralegals do a lot of landlord tenant work, small claims work. I like to go to the land tribunal. I'm wondering if the paralegals can do the Ontario Land Tribunal. Of course we can. Hey,
Yeah.
paralegals can do tribunals. So
Yeah.
there's a lot of different things, and it's always important to call us first to see if this is something that we could handle or whether our firm is involved in handling these specific cases. Hey, and those we can help you with.
Okay, so let's talk about the respective duties of the client or legal representative once a contract has been established. So we'll have to go through these, a set for the client, and then we'll go through the ones for the legal representative, and hope that all ties it together in the end. So
Yep,
for the client, it's important you understand the nature of the retainer.
yep. Generally, I have them in my office or in our boardroom. Usually, we meet people in our boardroom. But we meet people and we discuss with them the nature of the retainer. It's basically in the form of a contract. It's a 7 or 8 page contract that we go through, and it has terms and conditions of what it is of our engagement with you. And the retainer basically states that we are to handle this specific matter for you, and sometimes would include certain steps and up to certain steps as necessary. Like we don't generally say that, okay, we're going to go to trial at the beginning, but we will go to trial if necessary, because many of these cases don't go to trial, they get settled. So
Yeah.
there's a lot of different things that we talk about. And then it very, very important, we want to discuss the terms with you. And in the nature of our retainer, we do include how much our initial fees are, what happens when the fees start running low, and how low do they have to run before it come running back for you for more, and also under what conditions do you come back to pay us more. Okay, so it's very important,
Yeah.
and we are accountable to you for whatever money we spend. So if we spend and you give us say 1,500 to start with, and then we spend and everything comes up, and there's a settlement conference coming up, and basically we've basically prepared for it. We have all your settlement things. We've had a motion to serve somebody alternatively. We got them served. We got everything in there. Then there's a settlement conference as the case was defended. So we do all of that stuff. It goes up to that point. Then we go into the settlement conference. We say the settlement conference is coming up, and we would require a little bit more money. And we talk about this. Okay. And our firm tries to talk about this. And this is one of the things that sometimes the clients don't understand. Okay, and
Well,
there are other times that you pay us a certain amount of money, and I get it done in a few phone calls.
yeah,
So I said, okay, I'm gonna give you back half your retainer. It didn't take me as long. Here you go. Okay,
yeah,
but
yeah,
all of that is in our retainer. We talk about that,
yeah.
and if people, when we send the retainers, we want people to call us and talk to us if they
Well,
have
you see, one of the key aspects about that you just really touched on there is the fact that you've got things like negotiation. So a negotiation occurs, so we, under the retainer, we might say negotiate a way for you to get out of this contract. Take these steps, take those steps, take the other steps, right?
Mhm.
So 5 or 6 steps might well be in the retainer, because we consider at the time then we took the retainer that in fact we have to consider that the other side is going to say no, 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 we don't accept your proposal. And then every once in a while, because most of the time they don't accept our proposal, and every once in a while you go in with a proposal and they say, yep, okay, we're done, we're satisfied,
Yep.
we're out of here, right?
Yeah.
And the point being
But
is the
you always
retainer.
have to understand that, like a lot of times people say, well, if you just send them a letter, they will adhere to it.
Oh,
Okay, well, why don't we start off with writing a letter and see what happens?
yeah.
Okay. And if they don't respond, okay, within the time frame that we deem to be reasonable, or if they respond and say, you're out of it, you're full of it, you're lying, whatever, okay, or whatever their excuse is for not responding or not trying to cooperate, not trying to work with you, okay, then we have to take the next step. Okay, sometimes a more sterner letter, sometimes we need to start taking legal action, filing a claim. Okay, then we send that to them, we serve the claim on them. So all of these steps cost money. They're all part of your retainer, they cost money, trying to solve your problem. And we
Yeah.
work with you in there. If we have to draft a claim, for example, okay,
Well,
you are
we'll get to that.
responsible. One of
Yeah.
the things too, like we try to explain to you as we go, there's a lot of things that we require from you. So you
Yeah.
retained us. We're filing a claim against somebody. You need to talk to us about the facts of your claim or your defense. If you're defending yourself and you want us to handle your defense, you need to talk to us about things. If it's a criminal case, tell us what we need to tell the court about things. Tell us about yourself. You know, there's a lot of different things that we don't share with the court or don't share with the other hand when we're dealing it as a defense in a criminal matter, because we're trying to make sure that the crown is going to have to prove their point, right?
Yeah.
But in a case where we're defending things civilly, it's different because we have to disclose everything to the other side too, even if you're the one who is defending yourself. So you need to
Absolutely.
tell
Yeah.
us the facts that we need. Do you have
Okay.
emails? Do you have e-transfers? Do you have receipts that you need to prove to show that you had paid the money? Hey,
Well, and
information gathering is very important. You have emails, perhaps. Maybe you have text messages. Maybe you have a letter that somebody sent you. We need all of that. So these are things that
and
we cannot obtain on our own. You can get this because this is all part of your case and part of why you're coming to see us. Okay,
and
so
the
that we
point
can sort
being,
this out.
about some of this is that, um, many times I've had clients who say, "Oh, I've had a couple of times when people have said, oh, you got to the hearing, and the judge asks, well, have you got this? Have you got one of those? An invoice?" And the person says, "Yeah, I didn't think it was needed." Oh,
Yeah.
yes. Yeah,
Yeah, that's
absolutely, it
like
was
somebody
needed.
told me that a contract wasn't needed, a signed contract. And he said, well, I didn't think it was necessary. Of course, I flipped my lid because that's just going to cause a lot of embarrassment to the judge.
And actually, so essentially at that point, we're back to where we were with another matter a little while ago. Is how small do your big case that was giant, massive? When you started here, how big do you think it now is to the judge? Probably only this small,
Yep.
right?
Yep.
or
Like if
maybe
you go
even
into a
only
small
this small.
counter, they'll tell you it's small. It's small. I just want to remind you that this is a small claim.
No, I'm saying your believability went from, hey, I've got this is my right, this is my case, to being the judge seeing you as, your believability is this much, mate.
Yep, credibility is big
Yeah,
when you get
yeah.
into these things, and
So better
that's why
bring,
when we do information gathering and you bring
yeah,
things into us, we need to have as much documentation, as much proof of your claim as possible, because that puts your best face forward.
yeah,
When if we ever do have to take it to court.
yeah. Okay, the next element there is identifying potential witnesses. These may well be people that you've been speaking with during the course of your case. For example, your friend who's a contractor who couldn't do your ceiling, but noticed that the ceiling was badly done by the contractor you hired.
Yep.
That
Yep,
type of
people
thing.
like that could be called in as a witness. So if you remember their name, or if you have a neighbor who, like, if the case is about a dog that bit somebody, somebody else was with you who uh, saw the plaintiff with you and then
Yeah,
saw the plaintiff's dog instead bite your dog.
yeah.
Okay, so they could say that because this is what they saw, and then they can come in and we sometimes will take an affidavit from these people. Okay, so different witnesses we do need if you have people that you feel would serve your case. Okay, and we work with you to determine whether these witnesses are actually going to be viable. Okay, sometimes a witness works against you, so you have to be very careful.
Well, and that's the whole point about why we need to know about the witnesses early, because essentially sometimes you might talk to and interview a witness and they turn out to be just absolutely useless to your case.
Yeah, exactly. Like I've had cases where I've brought in witnesses and we would talk to them quite at length. I mean, good people, interesting, but they didn't really have any value to add to our case.
Yeah.
Okay.
Like what do you remember about what happened with Adam Smith? Who's Adam Smith?
Yeah. Who's Adam Smith? I don't remember anything. I didn't live in the neighborhood at that time.
Yeah, yeah,
Yeah.
like, and Adams assured you that that Mary Jones is the perfect witness, and Mary's going, I don't even know who Adam Smith is,
Yeah.
right? So
Yeah. That
you're onto a
rarely
loser at
happens,
that
but it
point.
does.
Yeah. Okay.
So that's why I say be careful who you choose,
Yeah.
but we can help
Yeah.
you try to understand where you might look.
Yeah. The other thing is, okay, for example, evidence gathering for the client, text messages, emails. How many
Photos, things like that.
text messages are being used today through our courts? Who would have thought that the mobile phone and the text message you've got on your mobile phone and the chains of text messages might be the most important thing you've got in
Hmm.
your claim?
Yeah, because everybody communicates with their plumber, their electrician,
Yeah.
their next door neighbor, etc., through text messages.
Yeah.
Okay, they even complained to somebody, said, "Hey, stop the noise up there. I'm trying to sleep. My baby's trying to sleep." You know,
Yeah.
so things like that. You send these things, so you know that these text messages are there and they could be used
Yeah.
for evidence.
And the great thing about that was, like a neighbor complaint, is you send the text message out at 2:14 a.m. What the F are you doing shouting so bloody loud? I'm being disturbed. I need to get to sleep tonight because I'm going to work at 6 a.m.
Yep, or they got a
Right?
chainsaw going at 3 in the morning, and you wonder
Yeah.
what they have a chainsaw going at that time.
Yeah. Exactly. Exactly. So there's a heck of a lot you can get from a text message. And the point about a lot with text messages is that they help us actually create your claim or help you build your defense.
Yeah, and they're
So
dated, stamped, you
yeah,
know,
date stamped and
who
everything.
sent it, and if they responded, all it's very, very helpful. So this is why when someone has, well, this Joe guy, he started bothering me last spring. Okay, send me the whole chain of text messages between you and Joe since last spring.
Yeah.
Yes, some of it's not going to be relevant, but I need to know, go through it, let us decide what's relevant.
Well, and actually, the funny thing is about that is that I had a client come in with a text message, and he says, oh, "I've got this one from the first. I've got these 3 pages from the 1st of July. I've got these 4 pages from the 6th of July, and I've got these five messages from the 12th of July." And I said, "Yeah, but what about the rest of the chain of emails between you?" Well, there's nothing in there,
Yeah,
right? Yeah, there was nothing in there until the defense put it up,
yeah,
right? And the defense put up your lame dog, your client's lame dog, you know, slam dunk lose text,
yeah,
right? Let
exactly.
us look at
Why
all of the text.
all the text, I need all the chain of the
Yeah,
text messages that you had with Joe Blow.
yeah,
Let us determine if there's anything in there that's not relevant. Like usually we put the text messages up and then we highlight the ones that are relevant and then we put them into tabs so that we could refer to tabs if it ever had to go to court or for a hearing.
yeah,
And that they're clearly something that we can point out where a communication chain starts that's relevant.
yeah. Okay, so moving on, for the client, inform your legal representative when something new happens or something changed in your case.
Yeah. Like my
Right?
employer
For
fired me.
example, for example, the insurance paid the claim.
Yeah,
Right?
exactly. But
Well, they offered you 15,000 when you only expected 3.
yeah. Hey, I
Right?
would say by all means take it.
Yeah.
Hey,
And obviously it depends upon the situation, but
yes.
yes, but that's the sort of thing. So essentially, we only work on the information that we've got. And if you suddenly tell the judge, if the judge asks you a question at a settlement conference and says, "Well, why didn't you take the $15,000?" And your legal representative's looking at blank, look, what the f? Why didn't you tell me about that offer,
Mhm.
right? Sometimes, it may be relevant, it may not be relevant, but it's best to ask,
It's
check
best to give
situation
us that
change.
information. It may be important.
Yeah,
Okay, and sometimes we can look at that and we can determine whether it's a reasonable offer that if you lose when you go to court and then you get less than that, you could end up with big heavy costs on that.
yeah,
So there's a lot of things that your legal representative knows, that you really need to. That's why you need to be communicative all the time with them about things. No, not every 5 minutes. You don't call them 3 times. You
yeah.
call them like once every whatever, like every month or whatever, or when something important happens.
And the other aspect that we didn't put down a tag for this one is keep your payments up. Be willing, when you sign a retainer agreement is only initial spend on your file, with whether you're working with a paralegal or working with a lawyer. The retainers are basically the initial amount of payment that you make. Once you are involved in a case, you have to pay more to continue on. And potentially, one of the things we do with many of our clients is ask them at a certain stage, hey, once we go into the trial, we're going to need, this is going to be a 2-day trial, we're going to need a further $2,000 worth of for the trial, etc., the expenses. If you want to, actually, what you can do now is pay X amount a month. So you're paying ahead, you're ready and
Yeah,
prepared for the trial, even though right now we don't have a date for you, right?
yeah.
But
So
you'll
there's a
have,
lot of things we work out, because sometimes a trial isn't until several months away, and then you have some time to make some monthly payments
yeah,
to put in place and helps us prepare for the trial and also to be paid for said trial. Okay.
yeah,
And then if we don't end up going for trial and we settle it prior to, any monthly payments minus what we did work did, and then you get some of it back.
yeah,
So these are things that are explained very clearly in our retainer agreement. Okay. Like these professional services aren't necessarily cheap. Like people think that people like lawyers, paralegals should be providing services for cheap, and they talk about access to justice. Okay, but the thing is, these are skills that people have learned, and they take a long time to develop these skills. And many people are trained and they're very experienced. And I've seen certain things happen before, and then I use my professional knowledge to be able to apply these skills and to be able to assist you. Okay. And this is where it is. We try to be as cost effective as we can. And sometimes we will go to one of our associates or newer associates to provide the service and that sort of thing. And then there's others who are always on a monthly payment plan to pay for the
Yep.
retainers too, which is fine too. There's ways people organize and that sort of thing. We work with anybody, and we also have credit card payments, other payments for people who want to work with us, And the thing is, because what generally happens is, say, if you give us an X number of dollars, we start your work, and then we get to an endpoint, like say maybe filing a claim or something. Then after that, we really can't do much more until we get paid again. And yes, we're allowed to stop work if payments are supposed to continue. We're allowed to stop work. Okay, so you really need to be aware of this. Okay,
Yeah.
so it's something that we spell out carefully in our retainers. Because we want people to understand, what these things are.
Okay, moving on then. We've talked therefore about the client's duties and responsibilities. Let's now talk about the legal representative. So part of that is to identify for the client the implications of the retainer.
Yeah,
So we're
well,
back
this is
to the
another.
beginning, the
Yeah,
retainer,
that's
which is
why.
the,
Yeah,
which
I
is the
always
opening
like
of the legal relationship between the lawyer or paralegal and
yeah,
the client.
yeah. I always like to make sure, like if I'm sitting with them and I give them the retainer in front of me, I usually like to spend some time with them to go through each part of the retainer and ask them if they have any questions, because I want to make sure they understand what they're signing. Okay, because I don't like them to sign the retainer and then come back 3 days later and said, I didn't know this part of it.
Yeah.
Okay, because I like to make sure people understand what we're doing for you, what we can expect, when I talk to you about it. And also we talk a little bit about cost wise, over time, what it might cost or what it might not cost if we manage to secure a settlement.
Yeah.
So there's a number of things we work on in
Well,
that.
that said, trying to find a settlement it is a professional duty of every lawyer and every paralegal to look all the time, irrespective of what stage you're at, to find a settlement. And let's be blunt
Yes.
about that.
Yep.
If your lawyer or paralegal is gung-ho about going to trial, you should be questioning that, right?
Yep.
Because settlement is actually always has to be forefront of your mind as
Yep.
as a represented person.
Yep. And
Right?
settlement has to be something that needs to be acceptable. Like I would go back to the other party, either party's representative, and I'd say, okay, let's talk it. And they come up with some kind of settlement arrangement and they come back to me. I don't do anything. I don't accept anything on your behalf until after you've read it and we've had a chance to talk about it, what the implications of that settlement would be. Because that means if you agree to that settlement and then you sign off on it, you don't have a case against that person anymore. You cannot do that. And
Yeah.
it's often signed where you have some kind of non-disclosure arrangement involved, because particularly say if it's an employer and they fired you and then they paid you off a good settlement package. But then there's other people. So this is why you have to have a non-disclosure arrangement, because otherwise you get lineups, eh? If other people are equally unhappy with that employer. So
Yeah.
yeah.
Well, it's non-disclosure agreements occur in a wide range of areas,
Yeah,
including
even
including
between
things like
businesses. Yeah.
yeah, including like tenant exits from a tenancy and that sort of thing.
Cash for keys.
Yep.
Yeah.
Yep. Okay, so now also the legal representative must understand the facts of the client's case.
Yeah. We need to make sure we understand the facts, and that's one of the things that we do. Like, we like to show you a copy of the claim that we have before it goes out. And we want you to look at that copy of the claim to make sure that we're getting it right. Do we make changes? Do we add something? Or do we change something entirely? Or do we get rid of something entirely? We want to make sure you're happy with what we're sending out.
Yeah. And a lot of that starts from the very beginning of the relationship because, for example, we need to have the relevant facts and evidence in our hands in order to understand what the facts of the case are and draw our own conclusion about possible theories of the case. Right.
Yep.
I talk about theories of the case because the theory of the case is something that we all need to, well, in order to go to court, in order to actually run your case, make your claim through the court or tribunal, the legal representative needs to develop a theory of your case.
Yep.
So one of the aspects here is that they also need to inform you, the client, about what strategies might well be best. So
Yep.
that
Because
comes
some
from
strategies are better than others. Some may act quicker than others.
Yep.
Some may yield more money for you. Some may yield less money for you. But there's a lot of different things. Like employment law, there's about 4 or 5 different silos you can go for in employment law. And many times you can't be doing forum switching or forum selection. Like once you start with a forum, you can't be going into another one and trying to argue the same case because they'll be
you can't argue.
Data.
You can't start a case, for example, at the Labor Relations Board and then move it over to small claims.
Yeah, because then you'd have to. Well, if you just started and it's early enough, you'd have to give a 2-week notice exit, and then you'd have to go.
Yeah.
But there's other situations like, do you have a union at your job? Hey, and there's different ways that we can approach it if the union is not acting for you. But there's also human rights tribunal if it's a human rights type of case. Hey, we could still go to the human rights tribunal. So there's different things that that we have to look at and talk to you about, because sometimes people come in and they talk about, well, I have a human rights case. Can't we just take this to the Human Rights Tribunal? And I have to look at it, and I have to tell them whether it's something that could go to the Human Rights Tribunal or being able to argue. Okay, does it have the type of connection between a service or a job or something like that with one of the social areas of discrimination? Okay, even if it's partially that way, you can go to the tribunal. Okay. So, I mean, there's a lot of different things we have to examine, and there has to be some evidence that we can use to back it. Okay.
Yeah.
Having your word against somebody else's with virtually no evidence is not going to do anything.
Yeah. And that's one of the reasons we keep going back to it. Bring in your evidence, right?
Yeah.
Let us assess whether the evidence is any value or not.
Mm-hmm.
Right. And okay, so one of the key factors we talked about is for a legal representative to formulate a working theory of the case. Now, your working theory may change over time, but typically what will happen is you'll get the client walks in, the tenant who's my landlord doesn't do this for me, doesn't do that for me, doesn't do the other for me, right? So you start to formulate an idea about what the opposing party's like. And to flip that around, you get the landlord who said, the tenant, I've asked him to inspect the place on 15 different occasions. He keeps rejecting me, and you know, et cetera, et cetera, et cetera, things going on. I suspect he's doing drugs in the unit, or selling drugs in the unit, or something like that.
There's
And
always a side to the
yeah,
story that, we need to hear these things.
yeah, we need
And
to
the same in
actually,
one case, and this is why it's very, very important to bring in all relevant evidence, even if
yeah,
you feel it works against you. I had one client who told me that they did not sign a particular contract. They don't remember a particular contract. They had two contracts that were involved with this particular big job that he had. He remembers signing the first, and he was paying for the first, but he told us he did not sign the second. And then there was some question as to why they went ahead and started doing a lot of stuff, but he objected to what they were doing. And then when we went to it took all the way down the trial. They did not, the defense, the original people who were taking him did not bring the documents to me, nor did they share it with the court until the day of trial. Then all of a sudden, on the day of trial, like magic, this signed contract appears. And things like that, don't do that. Don't allow that possibility to happen. If there's a possibility you might have signed the contract, bring it in.
yeah,
Or get me to ask for a copy of it
yeah.
from the other side, because the other side will have it. Guaranteed.
Well, actually, that's the funny thing about this, is that you know, we talk about you know, give us all your evidence, the damning evidence especially, and they said, why? Well, because I can guarantee you the other side will embarrass you if they need to.
Yeah, because we were arguing that there was no contract, so why were they following through on this stuff? And then this changed the whole theory of the case when the contract was brought up. So we had to quickly come up with another formula, you know, and we had to argue on that way. Right?
So there we go. Dwight's basically backing us up and saying, yes, with Labour Relations Board, if you file a claim with them, you cannot file a claim in any other jurisdiction for a remedy, and you have a 10-day grace period to withdraw your claim after you file with the Labour Board if you choose a different remedy in a different jurisdiction.
Yeah, definitely. There's people who decide they're not going to the Labor Board. There's some very good benefits of going to the Labor Board in certain types of cases. That's why you need to talk to someone who is a specialist in the employment area, who can tell you whether that is a good idea. And sometimes you can only go to the Labor Board for certain things, because there are employers around that don't even pay minimum wage, let alone pay overtime, pay all these different things, don't even give breaks. The Labor Board would be very interested in these cases, and they would be very interested in the employers that are doing this.
Of course.
They would be forced to pay you,
Yeah.
and possibly other damages as well. But there's other things too, that, like other cases when you're getting wrongfully terminated, there's other avenues to go through that for that reason.
Yeah. All right. So for the legal representative, using the client information that the information the client has provided and the evidence to build or defend the claim that you have in front of you.
Yep, exactly. So that's what helps us. All these wonderful paperwork and all this piles of stuff, and helps us kill all the trees to do this. Helps us do that.
And essentially, this is the nub of the work that we do, right? Because somebody's made a claim against you, and you're saying, "Hey, for these reasons, I didn't do it."
Yeah.
Right. So that claim, we've got a whole heap of reasons why you did do it, because it's being claimed by the other side. You know, yes, you can deny that to be the truth.
Your fingerprints are all over it.
You can deny that to be the truth. You can come up with your alternative story, but again, at the end of the day, it all, you know, it revolves around us building the claim or the defense for you, right?
Yeah, and it has to be based on facts, evidence. And then when we put the witnesses on the stand, or yourself on the stand, your credibility.
Yeah, exactly.
Credibility is a complicated issue. We'd have to talk about that another day. But the judge looks at that. Okay?
Oh,
If the case can go either way, it's credibility.
yeah, as does every adjudicator in every type of situation. And you think you've got the case that's this big. It's $1 million case, isn't it?
Mm-hmm.
And it all turns upon one point whereby the judge or the decider of fact is looking at the evidence that is given, and somebody says, oh, hey, you've got this much credibility at this point, and then you're cross-examined. But Mr. Smith, didn't you lie about this? You gave this you gave this employment letter that you worked for this company, but you lied about working there, didn't you?
Mm-hmm.
Right. Now you look about this small, or even the judge wants to flick you away from the case altogether. Right.
Yep.
The judge is like looking at you with this with utter scorn. Right.
Yep. And the judges, when they look at you, they're not just looking at your case from what's there that day. They're also looking at what the appeals courts would say.
Yeah.
And the upper courts would say. So if he makes a decision, he has to look at that too.
Yeah. Okay. So the other question here is for the legal representative reviewing their work product with the client. It's an important factor here.
As I said before, when I draft a claim on your behalf, before it goes out, say, to a landlord-tenant board or small claims or to any kind of tribunal, I send that out to the client. I want you to look at this. Please read it carefully and tell me if there's some issues. Some clients actually like to come into the office and review it with me in person, and that's fine. Or they can talk on the phone with me, or they can just send changes in writing, like they can say, paragraph 15, you said this. This is not true. Please replace it with this. And that's fine. Right?
Well, in
We
fact,
want to make sure that what we're sending out is what you want to have sent out.
In fact, actually, I would prefer for you to say, well, because I write things when I write something with the best of my knowledge at the time I do the writing.
Yeah.
So on paragraph 15, I said on the 1st of July, I might actually then put a question mark, double check the date.
Canada Day, okay.
Right. On the 1st of July 2023, Mary Jones did X to Y, to John Smith at the Canada Day celebrations, and caused John Smith to cause the plaintiff John Smith to have a heart attack, and John Smith has never felt the same since, and etc. etc.
Yeah.
But and I'm working on the basis that of the information that I was told by my client. Now it's the time I'm putting you, Mr. Client, on the chair, because in fact, if I got this wrong, tell me now.
Mm-hmm.
Right? Because this is the last opportunity you have to fix it.
Yeah. And in some of our claims we put forward, we use or apply case law, particularly when it's something that is like brought to the landlord and tenant board or to the human rights tribunal where there were prior cases decided on this. We'd have to do a lot of research because we want to make sure that your case fits in with other cases that were decided, particularly with a higher court. So we want to make sure the tests are met and so forth. And that's why we're trying to make that argument.
Yeah. And in fact, actually, so the fact that you might review this and you suddenly thought, oh, that wasn't the 1st of July 2023. No, that was September the 5th, 2022. Oh, that might make all the difference in the world.
Yep, exactly.
Right?
Because there's time frames. There's something that could have happened on that day that could have happened, or there might be a different ordering of events. And sometimes the ordering of events makes a difference for your case.
Okay, Dwight says, yes, if the evidence is weak on both sides, but credibility has value, it may turn on who has more credibility or impeachable than then the other is deciding the outcome from within the adjudicator's findings. Yeah.
Well, there is some case law that actually determines things around credibility, where there may be a certain issue where, like, say, in some criminal cases or provincial offenses cases, you'll have a police officer or a bylaw enforcement officer or somebody who goes up and gives testimony that is very weak and discreditable. And if the defendant sounds credible, consistent, and so forth, that they will win the case and they will successfully defend themselves.
Yeah. Oh, yeah. Yeah. Okay. So in terms of going through the case and getting everything off and ready for the courts to hear the matter, so one of the key factors about the duty of the representative is to prepare the evidence for submission.
Yep.
Right. This is typically
sometimes can be a lot of work. Like, for example, the Landlord-Tenant Board has these portals that we have to provide evidence through, and they go into, each file has a portal. Okay, that we have to go through that, and it goes in there. Okay, file number this or that. This is so we have to upload all the videos, all the letters, all the documents, everything there. Sometimes we'll do a document brief where we have all the documents there in a PDF format, and then we have separate video files. Okay, so we would have all of that submitted. But that takes time to create, so we have to take time to create all of those and put them in order of some way to be able to, so that we can make our arguments on the day of the hearing. And for things like small claims, sometimes you have to make a pretrial booklet or a trial brief where we're bringing that in, where it has all the documents. And if there's a video that we would have actually acknowledged that we have ahead of time, the other side has the video, and then we can present that at the hearing.
And one of the small trial claims that you and I attended last year, there was a 4-inch book of evidence that was put forward.
Is that when you and I both had the flu?
Yeah, that was the one. Not the flu. I had a cold. I had a severe cold, not the flu.
Yeah. Yeah, and we were given lozenges and everything else. And
yeah, I lost my voice at that. Okay, so Dwight says, you guys and gals are great with this show. I always look forward to it, but I miss the live show. We're live. We're live
right now. We're live right now, Dwight.
Yeah. Okay, but okay, so that's preparing evidence, and of course, all of this then culminates in the actual trial itself, doesn't it?
Yeah, and then we go to a hearing, go to a trial, and that's when we represent and do our magic. As I said, there's no Perry Mason in this stuff. Okay, we just don't come up with magical things that just come out of thin air. Okay, because everybody knows what the other side is doing when you go into a civil case.
Yeah.
In criminal case, there's some differences. And there's some ethical responsibilities of disclosure even on the defense, but it's not a full disclosure as they would have like with the Crown. But the Crown has to have a full disclosure over something called Stinchcombe, which is a decision for Crown disclosure. But there's a lot of different things that we know about, different cases that we know about, that we rely upon to make sure that when we go to trial, that we're first of all bringing credible witnesses to our side of the case, and then making good attempts to discredit the witnesses on the other side of the case. And then we bring final submissions at the end to repeat our arguments, to ensure the judge has it in their head exactly what our case is about, and the other side would do that too.
Yeah, and somewhere down the middle, between this side and that side, the judge will make their mind up. They will plot their path through the evidence that they're presented with, and be plucking this from here and this from here and this from here and this from here, and be saying, okay, I believe this happened. Right?
There's things you can put in there. Like I argued one case few years ago. It was a 7-day long small claims case.
And the judge said, this is small claims.
And at the end of it, I won the case completely, all of it, and I won my costs, everything. Okay. But it was a lot of work. And he had this one lawyer who came, but just at the end of it, he says, "Excuse me, I really only know all the summaries of the case that we had last time." And then he had read the transcripts of it. And then he made arguments. Okay. And that was when I first met this lawyer at the time. And I enjoyed that. That was one of my interesting cases that I've had. But 7 days long. And this judge, for many years afterwards, he's no longer sitting right now as judge, but he used to always tease me and make jokes about it that I had the longest small claims court case.
Small, small.
That was a Tarion case.
Yeah.
We went, that was a big, huge. We had 3 big, huge binders, and then the court clerk says, "Is this all for us?" And I said, "Yeah, all of them." She says, "Yeah, this is a small claims court."
But in fact, but you see, one of the things I did from bar school that I still remember from one of the lecturers at bar school was saying, for many of you out here, you'll cut your teeth in small claims court as you start to actually go to the bar. Many of the chambers will actually send young barristers to the small claims court to actually cut their teeth in how to do that type of law.
Yeah, we get students.
And the point being is that, and the point he made,
it's work and partners.
Yeah. And the point he made was that small claims court isn't necessarily, the figures may be small, the monetary compensation may be small, but the legal issues may be massive.
Yep, because some of them are complicated.
Yeah.
Like when you're dealing with nuisance issues, pollution issues, or tort issues related to product liability, different things like that can be brought through small claims.
Yeah. Oh, yeah. Okay. So we've got our standard disclosure at the end of this. So if you need to contact Invictus Legal, you can do so at 905-688-5598 or email Angela at weareinvictus.legal or me at peter@weareinvictus.legal and our website, which is down in the comments beneath. We https //weareinvictus.legal. There you go.
Yep.
Okay.
Yep, you took the comma out of it. I think it was last week when we did our show. There was a comma in there.
I took the comma out this time, yes.
Yep.
And for Angela.
Yes, and this is what I do every week when we do the Spin Legal episode. We remind the audience and people who are seeing us right now that we are not giving legal advice on the show. That whatever we say on the show is not legal advice that might be specific to your situation. If you need legal advice that applies to your situation, then you need to contact a paralegal or a lawyer. It'd be nice if you contact us, but just contact a paralegal or a lawyer. Okay.
And Dwight says, thanks for the live show. See you again next week. There we go.
Yes, there you go. Yeah, we were a little bit late today. We had been client meetings all day.
Yeah. Yeah, but that's the life of being here in this paralegal practice.
It's called practice. Hey, it's all practice.
Okay, and thank you everybody for being here, and we will return with Spin Legal this channel next week at on Wednesday evening at 6:30 ish.
Yeah. Okay.